I wanted to welcome everybody to this panel on the relationship between data protection authorities and data protection officers, or CPOs as they're called in some countries. My name is Charles Raab from the University of Edinburgh, and I'm delighted to be chairing this panel with Szekely as the moderator. Today is the day for DPA panels, for DPA junkies in the audience, because there's not only this panel on DPAs and DPOs, but there's another one at 1400 on cooperation between DPAs, plus one later on DPOs and the European data protection reform, and a later one on DPAs and complaints handling. So you can get your stomach full of DPAs and DPOs today. Now this panel is part of a series of panels that Ivan and I have been running at CPDP over several years, dealing with topics like the independence of DPAs and the cooperation between DPAs and so on. And today we're looking at the relationship between DPAs and data protection officers or chief privacy officers, and what the implications of the data protection reform might be for that relationship. And we think it's a very important relationship between those two, but the roles of DPAs and the roles of DPOs and the relationships have not really been very well researched, although some of our panelists, or one of our panelists indeed, has attempted to do some research in her own country, and you'll hear a little bit about that later on. There has, of course, been some interesting work on DPOs in North America by Kenneth Bamberger and Deirdre Mulligan, and some other work as well. And that research has looked at such questions as what is the status and the influence of DPOs in their companies, within their management structures, how they relate to other employees, and also from whom they learn what to do from external sources. But I think not only do we need more of this kind of research to be done, but we have to look within European countries particularly to get a fuller picture of how this pair of roles, DPA and DPO, work out in practice. And this is partly because we have more visible and important regulators in Europe, the DPAs, than in the USA, and also because the expectations and assumptions of what DPOs should do is arguably not only somewhat different, but also very variable across different member states. And we'll hear something of that today. There are different data protection regimes and different laws, different kinds of DPAs, which affect the nature of that relationship. Now this provides the basis for the theme of this panel, which I'm not going to read out, but you can see it on page 31 in your program, except to mention the kinds of questions that we're going to be dealing with in the panel. What's the relationship between DPAs and DPOs? Where do they lie on a continuum between adversarial and collaborative? Is there a danger of regulatory capture between DPAs and DPOs? And how are these relationships likely to change under the advent of the proposed data protection regulation? Articles 35 to 37 of the proposed regulation specify the requirements about DPOs, their positions and their tasks, and we reserve that particular question about the new regulation until the later part of the panel discussion. Now, to consider all of these things and other matters that they might intend to raise, we have a very highly experienced panel of 4 persons whom we have selected because of their combined experience, sometimes on both sides of the line. All 4 of them have been regulators in DPAs. 2 of them are now DPOs in companies. Among them, they have worked in 3 different countries, the UK, Germany, and Austria. I'll only mention their names now and later on give a bigger introduction to each speaker and where they're coming from, as it were. But the 4 speakers that we have are Waltraut Kotschy from Austria, Stephen McCartney from the UK, Emma Butler from the UK, and Peter Schaar from Germany. And Szekely, as the moderator, will use his expert skills to ask probing questions of the speakers, but also to involve you, the audience, interactively in this panel. And I will now hand over to Ivan.
Thank you, Charles. I will stand up every time when I will say something. I'm sorry for that, and that's the reason why I'm wearing this very fancy portable microphone, thanks to the technical staff. I will moderate this discussion, but besides, I will ask short questions between each presentation to the panelists, but also to you, and sometimes playing the role of the devil's advocate, as you would expect from me. And let me start with Charles, with the chair of the panel. In this list of questions you can read in the booklet, program booklet. There's a question, your question. What do you mean by, I quote, the danger of regulatory capture through close relationship, whereby DPAs go native? Would you elaborate?
Okay, yeah, the term regulatory capture might not be familiar to everybody, but what it means really is where you have a relationship between a regulator and the regulated. If that becomes too cozy, then in a sense it could be that the regulator gets captured by the regulated, so that the actions that they do or the things that they don't do stand against the public interest. And regulators are put there to defend, to protect the public interest in this instance in terms of protection of privacy. And if they get too close to the regulated, this could present a problem, because they then might be captured in the sense of going easy on them and not being vigorous in enforcing compliance and turning, looking the other way. So that's the danger of regulatory capture, in which the regulator goes native with the people that he is trying to encourage to do best practice, but still may fall into their clutches. So that's a danger.
Thank you. I think Stephen will have some comments on this. But we'll see. And now I'm turning to you, to the audience, already now. During our panel, we will use two acronyms, as most of you already know. Maybe we'll use it too often. But to make sure nobody will misunderstand that. DPA will use it for data protection authorities, and DPOs for internal data protection officers. It's shorter, so we'll use it too often, I know. Sometimes we can also use CPOs for chief privacy officers in other environments. So let's try to test it now. So those of you who is working or worked in the past in DPAs, data protection authorities, in any function, please raise your hands. Could you help me to count? But I think it's roughly 15 or something like that. Thank you. Those of you who are working or worked in the past as DPOs or in similar function at data controlling organizations, data controllers, please raise your hands. More? Yes, let's say 20, more or less. Thank you. We know that there exist more DPOs than DPAs in the world. And those of you who have been working in both positions during your professional career, please also raise your hands. 1.5. Plus at least 3 members of the panel. So we know that the population density of DPOs and DPAs are much higher in this room than in other segments of society, but I would like to underline that we have the privilege to have these special segments overrepresented in our panel. So I give back the floor.
Thank you very much. I'd like to call now on our first speaker, who is Waltraut Kotschy. Now, Waltraut served, as many of you will know, as the head of Division for Data Protection and Reorganization of Administration for the Austrian Prime Minister, and then for 7 years, she was the executive member of the Austrian Data Protection Commission, so she was a commissioner. And between 2000 and 2006, she was the DPO of the Council of Europe, and since 2010, she is the head of Data Protection Compliance Consulting, which is a trainer for Professional Training Academy, and is a trainer for Professional Training Academy for internal DPOs and as Senior Research Counsel for the Ludwig Boltzmann Institute. I'd like to call on Waltraut to speak for no longer than 10 minutes as our first speaker.
Thank you very much. I'll try to do my best not to override the 10 minutes limit. Coming from an Austrian background, and I understood the first question of our chairman that we should report, first of all, about our experiences, that is, about facts. Coming from an Austrian background, I have, first of all, to report that in the Austrian DP Legal Act, the word DPO doesn't show up. We do not have DPOs in our data protection law. However, in my teaching work, which has been quoted here, I always meet people, practically, who say they are DPOs or they want to become DPOs. So evidently in Austria, although we do not have DPOs, there is in the market a demand for DPOs, and in reality, even there are evidently people who think they could call them justifiably DPOs. So I think I should not just say I can't tell you anything about DPOs because we don't have that in the Act. On the contrary, I think it's a very interesting situation to look into reality why and how DPOs have been developed in Austria in an environment where there is no legal obligation. So what did I find on the market? I tried to make a tiny little survey as much as I could in the short period which I had to prepare. And I was interviewing some DPOs from institutions in the private sector, which for Austrian standards are big. And I asked them, what is your own perception of your position? Do you have a strict paper, perhaps, which describes what you have to do, what are your duties? What is your position concerning possible dismissal and all these tricky questions? And after interviewing about 10 people of this sort of character, I can quote the following results. Nearly none, so only 2 of these 10 could really say that they have, let's say, a guideline of top management describing exactly what their duties and obligations would be as a DPO. The rest of them have a rather fuzzy perception of what their tasks are, but all in all, naturally, they have all to do what are these more formal things, like we have a very heavy notification system, so they certainly have to prepare all the notification things, they have to take care of access requests, and that is without doubt the same for all the 10 of them. But then the question arises, how do you see yourself? Are you, first of all, an advisor to the top management, or do you see yourself also as somebody who fights for data protection rights, let's say especially of the employees, or even do you see yourself as somebody who fights for data protection of the general public, of the customers of your company? And there I felt that actually most people feel themselves to be real employees of the controller. And a real employee actually has, at least according to Austrian labor law, his main obligation is to stay in good faith with his employer. So actually, all his actions on behalf of the controller would have to be somehow at least with tacit consent of the controller, if this DPO acts in a fashion which has consequences outside. So on the whole, I would say in the private sector, what has been developed outside a legal obligation and outside a legal description of the tasks of a DPO is an employee who is a specialist in data protection law, who is wiser than others also in technical ways and means of probably safeguarding data protection, and who feels himself to be an organ of the controller. Having made these statements, I can come to the actual topic of our session. What is the relationship of such a DPO to the DPA? Well, I think that clarifies a little bit the possible relationship. If the DPO is not the entrustee of the general public to safeguard data protection at the controller, but if he is the employee of the controller, being the specialist for data protection, he is responsible for giving good advice, but he is rather not responsible for taking outside action in order to force the controller to keep data protection. And therefore, the contacts between the DPOs in the private sector to the DPA are certainly there in Austria. They are well known to each other. But it is, again, only a situation where the private DPO perhaps seeks advice of the DPA, but with the tacit concern of his employer, not in a way which could compromise his employer. And therefore, the answer to my question, do you probably have in your labor contract any special provisions against dismissal? Is there anything you could tell me, allowed to tell me? I usually got the answer that there is no specific provision, because they are in a situation which is not so different from other specialized employees who counsel or give counsel to the top management, and in the end it's always the top management which decides what has to be done in the area of data protection. The last 3 minutes which I have, I will go to a speciality of Austrian law, which is I have been told, unique. That is a certain sort of DPO in the public sector. We have in the ministries of Interior, in the ministries of Defense, and in the ministries of Justice, we have special DPOs. They are founded on special law, where they have a completely different role to play. They are completely independent, although they are appointed by the minister. And their task is actually one of control of covered data collection and data use. So every case of covered data collection has to be reported to this sort of DPO. He has to give his opinion, and if his opinion does not coincide with the minister's opinion in the end, he has the legal duty to apply to the DPA. So there you see that there's a completely different solution, which we are rather happy about, because it gives at least a certain amount of security that covered data collection and use are under special sort of eyes. There is somebody from the outside who looks into what these 3 ministries do in this sector. Also, you see, in Austria we have very different standards for DPOs. On the one side, we don't know them even, and on the other side, there are some which have a very, very powerful position. Thank you.
Thank you very much, Waltraut.
Thank you. I think this special DPO is really unique in Austria. But let's try to concretize with you, with the help of the audience, the situation, the possible situations between DPAs and DPOs. Who thinks that this is the DPO's interest to conceal the questionable elements of data processing operation from the DPA, thus protecting his or her organization from criticism or adverse publicity. Of course, we are not talking about your organization, but who thinks that it's possible? Please raise your hands. Yes? Let's say 10. 10 people think. Okay, and who thinks that it is the DPO's interest to open up everything immediately to the DPAs in order to prevent future criticism or future adverse publicity, getting a kind of protected status? Who think that it's also in the interest, might be in the interest of DPOs? You can have multiple answers. So a bit less, okay. And who thinks that, I know it's provocative, but let's take it very simple. Who thinks that it's the DPO's interest to conceal the questionable elements of data protection, data processing, both inside and outside, thus avoiding any potential conflicts? Would it be possible in your opinion? Not in your organization, of course, but can you imagine such a situation? Just a few. Yes, it's a very, very reserved audience. I think we will now listen to the opinion of an acting DPO on this, and I give back the floor.
Thank you very much. To save a bit of time, I won't read out the background of Stephen McCartney, who's our next speaker. You can read it up on the board, except that Stephen is one of the people on the panel who has spent a long time working with DPA and now is working as a DPO, and he'll tell you about what that experience has been for him. Thank you.
Thank you, Charles, and thank you very much for having me on the panel today. I guess I have a very interesting background whenever it comes to talking about this, because I started off actually as an advisor to the public in Citizens Advice Bureau in the UK, and that's how I first started to advise people, individuals, on their data protection rights. I moved in-house into a health trust in Northern Ireland, and then I joined the Information Commissioner's Office in the UK, and I spent 8 years there. One of those years was with the European Data Protection Supervisor in Brussels. And so I was dealing in an environment where the data protection officer's role was enshrined in law within the EDPS. And I was working in an environment where the data protection officer's role isn't even thought of in law in the UK. I moved immediately from the Information Commissioner's Office to an in-house role in Google. You can imagine that that was a very easy transition. I spent a few years there, and then I moved to Royal Mail Group, which is the UK Postal Service. In terms of the relationship between the Data Protection Authority and the Data Protection Officer, I have to say that is very, very dependent on the nature of the organization you work for. I have worked in an organization, I will leave it up to you to guess whether it's Google or Royal Mail Group, where we were in constant battle with the data protection authorities, where we were constantly having to defend ourselves, and where my job was to explain what the organization I worked for was trying to do to protect privacy and meet its obligations. And I have to say that in that environment, if the Data Protection Authority is determined to find fault, then the relationship will always be adversarial. And even if you are trying to do the right thing in some cases, and in some cases it may surprise you to know that Google was, that you will never actually be able to have anything other than an adversarial relationship as a data protection officer with the data protection authorities that you're working with. Equally though, if you are working in an organization that is perceived by the Data Protection Authority to be being constructive and to be doing the right thing, then the relationship changes very dramatically, and you can have much more comfortable conversations with the Data Protection Authority about what your organization is trying to do. And so whenever it comes to what is the relationship, I have to say it is incredibly dependent on how the Data Protection Authority wants to interact with you and your organization. I have to say my role, I am unashamedly there to help the organization I work for get it right. I am unashamedly there to work for the organization who employs me. And I'm saying that because at the end of the day, if I go in and I am perceived to be an agent of the Data Protection Authority, I am not going to be trusted with the dirty secrets of the organization, and I am not going to be the person that they come to when they discover a problem and ask for help solving it. And so in terms of the outcome for the individual, I have to be looking like I am working for the interests of the organization that I work for. If I go off to the Data Protection Authority every time I see a problem, then very, very soon I will be in an honorarium role. I will be in a role where the organization calls me its data protection officer. It comes to me and says, everything's fine, Stephen, here's the audit we've done. Everything's fine, Stephen, here's the legal advice that we've got. Everything's fine, Stephen, here's your notification for the Data Protection Authority. Unfortunately, part of the data protection officer's job is to get our hands dirty, to discover the problems that exist within the organization. And actually, a colleague of mine who works for a different organization to the one I work for now, because there are representatives of ICO in the room, he said to me on Friday, whenever we had lunch, you wake up every morning as a DPO and you decide which breaches of the Data Protection Act you will tolerate within your organization today. And I actually don't think that's too far wrong. But you can only be effective if you have the trust of the organization you work for. Equally, thank you, I would say that you can only be effective if you have the trust of the data protection authorities. And of course, I would also say that that was another problem, that whenever I moved to Google, I have to say some of my former colleagues immediately thought that I had defected and that I had had some massive philosophical shift from where I was before to where I was now. And within Google, I think that there was a bit of worry that I couldn't be trusted, that I would go running to the DPA. But equally, the DPAs weren't very comfortable with me in my new role because we'd worked together at Article 29 subgroups. We'd worked together whenever I was at the European Data Protection Supervisor. So there was a change there as well. And I think as a data protection officer, you have to put in an incredible amount of work to make sure that you have the trust of the data protection authorities with which you work as well. They have to respect the fact that you're not going to come and tell them everything that's going on, but they also have to know that if you are asked a straight question, you will give a straight answer. I have to be honest and say that's much easier in the role I'm in today than roles I've held previously. I'll finish just by saying that in terms of regulatory capture, I don't think that is a danger, certainly in my experience, whenever you're working for a commercial organization. What I've actually seen is data protection authorities often, even though they come together at the Article 29 Working Party, are often acting in their own national interest. It's very typical in Europe. It's not something odd that this happens in data protection authority circles. And I think there's a greater danger of regulatory capture between the national interests of the country that the Data Protection Authority is representing and the Data Protection Authority within that country than there would be from, for example, Google and an organization going easy on them because, oh, it's all got too close. I actually think the bigger danger is the national interest that data protection authorities represent, and sometimes those lines between government and the authority can become a little fuzzy rather than anything else. Thank you very much.
Thank you, Stephen. That last remark was extremely interesting and provocative, and maybe we can take that up. But another person who has, no, sorry, over to...
just a quick question. If I'm not switched on, maybe? Yes, now, a quick question to Stephen. In your opinion, can a DPO of an organization owned by the state or performing a state function expect more collegial, more sympathetic treatment from the DPAs than his counterparts in the private sector. And that leads to our next speaker, whether her opinion will be different from this, from yours. But first, your opinion.
I think it depends on the state organisation. I worked for a state organisation as a data protection officer before I joined the Information Commissioner's Office. It was a health trust. And I have to say, in that case, absolutely not, because information is obviously incredibly sensitive, and you know, it enables the Data Protection Authority to do something very particular and get good wins for the individual. But I have seen examples across Europe where perhaps the way that the government is doing things is perhaps given a greater and easier blessing by the Data Protection Authority. I'll give you a very good example. Whenever I was working at Google and the Snowden revelations came out, across Europe, data protection authorities very quickly downgraded into attacking American tech companies. And I think, quite rightly, there needed to be a debate about that. But we very quickly forgot about looking within our own borders about what mass surveillance was happening, and criticism from data protection authorities to their own government. I wouldn't say it was non-existent, but it was muted.
Okay, thank you. We'll get back to this because, yeah?
That's what I thought. Sparks flying here. Our next speaker also has had to reinvent herself from gamekeeper turned poacher, or poacher turned gamekeeper, I don't know. Working now for LexisNexis. Emma Butler.
Thank you, Charles. Yes, I work for a company called Elsevier, which is like a parent company that has 5 different businesses. 2 of those businesses trade as LexisNexis, but they do quite different things. And the main focus of my role is to be data protection officer for those 2 LexisNexis businesses in the UK, and to assist my European colleagues where I can. So I think the first thing I'd say generally about the relationship between DPAs and DPOs is similar to what Stephen said, that it really depends whether you're on their radar or not. How interested are the DPAs in the sector you work in? How interested are they in some of the types of activities and processing that you're doing? And are you approaching them with some novel, innovative project that you want to talk through with them, or are you on the receiving end of enforcement action? That really dictates your relationship. Also, what type of regulatory authority it is. Obviously, my experience and Stephen's experience is mostly with the UK, but there are other data protection authorities in other European countries who take a different view of what their role is, and are not particularly open to relationships with organisations and DPOs within them. So clearly in those countries, sometimes there's just no relationship at all. I think from my experience in the UK, one thing I'd point to is that the ICO has an annual Data Protection Officer Conference. And this year it's 750 people. It's grown every year, and every year, from what I understand, at least twice as many DPOs apply for places as get places. And this shows to me that in the UK at least there's a really strong appetite between DPOs, or rather within DPOs, to have some kind of engagement, some kind of dialogue with the regulator, which I think is a positive thing. And my experience of being a DPO in the UK is that the ICO is actually quite a good regulator to deal with. They put out a lot of guidance, they put out a lot of views, position papers. As a DPO, that's really helpful because you understand the regulator's point of view. You've got their version, their interpretation of a particular aspect of law, the way they think things should be done. And basically, that helps organizations to take a consistent approach. So you've got organizations in a variety of sectors are all looking at the same bit of guidance, and they all know that this is the way the ICO thinks you should do marketing or deal with subject access requests. And DPOs take that back to their organizations and try and implement that as good practice. This is how the regulator thinks we should do it, so this is probably the way we should try to go. And you get a consistent approach then across all kinds of organizations to the same bit of data protection law. I think regulators who see their role as only being enforcement, for example, there's no opportunity for a relationship. And so organizations in those countries are left guessing, essentially, what's the right way to do things. They all potentially come to their own conclusions. I don't really see how that's a good outcome for individuals at the end of the day. And so I think at a high level, the ideal relationship is one where there's dialogue, there's engagement, and there's learning from each other. And I think moving that on to the DPO role in all of that, I don't think it's quite as simple as our panel description suggests. I think it's definitely a compliance function, but I think you're primarily there as a DPO to help the organisation get it right. And I would agree with Stephen that you are an employee of that organisation. You're there for their benefit. You're there to help them do a compliance job, to make sure that they don't stray, they don't go down the wrong path, that they get it right. You have to be a business enabler, a trusted partner. You're there to come up with practical solutions that meet both the compliance need, but also the commercial need. You can have a role, sort of based on some of the things Waltraut was saying. You can lead, you can provide direction, you can provide strategy. Ultimately, management might make the decisions about where the money goes and what's resourced. But you can, as your data protection expert, lead the way in saying, I think we need to do this year. I think we need to focus on this area this year. And the fact that you are an employee doesn't mean that you can't take account of the public, that you can't take account of the customers of the organisation. While you're looking to keep them on the straight and narrow, you've also got the situation where if we do something with our customers' data that they don't like, our customers will disappear. So there is very much that link between the traditional privacy aspect and the commercial needs of the organisation. And I think that's a good thing to remember. You have to be realistic. You do what you can and you encourage good practice, but you have to be realistic. Businesses don't exist to comply with laws. They exist because they want to make money and be successful. They develop a product or service that's in demand. They find a niche in the market. So they bring you in as a compliance function to help them make sure that they get it right from a data protection point of view. So you have to bear in mind what they're trying to do commercially as well and make the two fit together. You need the business to trust you. You need them to tell you what they're doing, what their practices are. You need them to come to you and ask for help. You need them to admit when things have gone wrong. And if they think you have some kind of reporting role where you're going to run off to the regulatory authority, that you're going to somehow just all about monitoring and auditing and controlling them in some way, then there's going to be no trust, there's going to be no communication. They're not going to come to you and tell you anything, basically. And if you have their trust, if they see you as their partner in helping get it right, in helping them meet their commercial needs, then you're actually in a better position to get stuff done in practice, proper compliance on the ground. So when you come forward and say, I think this is how we need to do things, they listen. Businesses are not static, so the biggest challenge as a DPO is keeping up with all the changes. And so you can't by yourself always monitor everything. You rely on the business people in the right departments coming to you, proactively keeping you in the loop, keeping you informed, asking for help. And so you need that trust there for that to happen. So I would say on the basis of that reality, the main gap for me in the relationship between DPAs and DPOs is a lack of understanding on the part of the regulator about how businesses really work, what processing takes place, and the reality of trying to do compliance on the ground. And I thought this when I was at the regulator, and when I moved into being a DPO, what I realized was actually the gap was wider than even I thought. So I think the relationship has to be two-way. It has to be educative. It has to be both sides prepared to learn from each other. But the regulator is always there to enforce if needed. And as a final point on the regulatory capture point, data protection authorities don't green light your projects. They don't approve what you're doing. So the idea that in having some engagement with you, they will hamper their ability to enforce if they need to is quite frankly nonsense. It just doesn't work like that. It's actually more effective to have dialogue and engagement with businesses, but if you need to enforce, you will do, and they do. So I don't think for a minute that this idea that there's some kind of issue and DPAs can't enforce if they need to, I just frankly think it's nonsense. And I think the regulation will bring risks to the role and relationship, but I believe we're coming back to that at the end of the panel. Thanks.
Thank you very much, Emma.
Can we have another blitz survey among the audience? Who thinks that data subjects primarily turn to the DPOs, if such exist, like Emma, with their complaints, because they regard DPOs as the best choice to solve their case? Who thinks that? Please raise your hands. Yes, let's say over 10 or 12 people. Thank you. And who thinks that the data subject primarily turn to the DPAs with their programs and complaints because they have more confidence in the authorities than the DPOs? Yes, a bit more. maybe 20 or 22 people. I can't count it properly. But who thinks that the data subject do not know of DPOs and DPAs either, and they expect the proper handling of their data protection complaints from the customer service? That's the case. Then yes, it's my opinion too. So let's listen to another experience from another angle.
Yeah. It's my pleasure to introduce Peter Schaar. And again, you can see his description up there. And he asked me to say that in his role as the managing director of a consulting company in 2002, he therefore was able to play a DPO role for a short time before he became the commissioner. So he knows both sides of the story as well.
Thank you very much, Charles. Germany went another way compared with the most other European countries. As you perhaps know, Article 18 of the General Data Protection Directive of 1995 gives the member states the choice between a comprehensive framework of notification to the data protection authorities or to install data protection officers, internal officers. In Germany, decided to go the way of DPOs. The decision or the reasons were that the DPOs were seen as a management function inside the data processing bodies, inside the controllers and the processors as well. And they could install procedures and can help the institutions to comply with data protection requirements. Not all companies are obliged to appoint data protection officers, but all bigger are, and there are thousands of data protection officers inside the companies, and some of them are also external data protection officers providing their advice and doing this job as a contract, in the framework of a contract with the companies and the public authorities as well. So the German Data Protection Act, the Federal Act, constitutes a specific legal status for data protection officers. There are some requirements of qualification and liability, but they also have a kind of protection against to be fired. So even after the end of their term as a DPO, an internal employee cannot be fired regularly before the end of the next year. So he or she is protected. There are also other formal requirements and guarantees in our Data Protection Act. The data protection officer has to act independently. This is also a requirement of our law in his capacity as data protection officer. Therefore, the role might be in a conflict with the role of an employee. So, although there is a clear definition by Data Protection Act, in practice, they are employees and they see their mission also to protect their companies and their employers. So this conflict cannot be solved by the law. The duties of the data protection officers are also defined by the law. They shall work to ensure compliance with data protection provisions, which are enshrined in the Data Protection Act and other legal provisions. And that means that he or she has to monitor the proper use of the data processing programs, and he or she has also the task to educate those who deal with personal data. So two main tasks. At first, as an internal auditor and an internal supervisory, not authority person. On the other hand, educational role, but at the end, the responsibility for the decisions of the companies remains with the CEOs, with the companies themselves. This is not delegatable to the data protection officials or officers. The data protection officers have a legal right to go to the DPA and to ask for advice. And on the other hand, it's a duty for the DPAs to give advice. This is also a provision of our law. And therefore, there is a more or less close relationship between DPOs and DPAs. There are jure fixes on sectoral basis. There are specific relationships with DPOs, organizations, and DPAs. DPAs are giving advice, and for them, they educate the DPOs about the criteria of their audits, and so on. But at the end, it's under the discretion of the DPO whether he goes to the DPA or not. So, and I think there the role, the actual role of the DPO is not as different as our law might constitute. I think the role of the DPOs in Germany and the role of DPOs in Austria or in the US are very similar. And there are role conflicts, of course. And we have a specific role, additional role conflict in Germany coming from our provisions, our legal provisions for co-determination. Our Works Constitution Act says that there is a co-determination provision between works councils and companies. And works councils are focused on data processing of referring to the employees. So they see themselves as super data protection officers in their companies. On the other hand, there are the data protection officers appointed by the leaders of the companies, and sometimes there might be different assessments, and there might also be conflicts between both. So this is a specific difficulty in Germany. There's another relationship or another problem. Many DPAs are not aware. That is that weak enforcement doesn't mean that there are very powerful DPOs. The opposite is right. If there's a weak enforcement, there are weak DPOs, because the role of the DPO within the company, within the organization, depends essentially on the strength or weakness of the DPAs. And therefore, I think DPAs underestimate this fact. And I was informally asked many times by DPOs to be more effective in enforcement. So DPAs are not the best friends of the companies. All DPAs know, but in fact there are some close relationships between companies and their interests and some DPAs. This is my impression. If you have trust in each other side, this is a good signal. But on the other hand, the question is whether there is a clear definition of the different roles of DPAs, DPOs, and the responsibilities of the company CEOs. Thank you very much.
Thank you very much, Peter. Ivan, do you want to go straight to the question of the regulation now, in view of the time, or do you want
First, a quick question to the panel, including the chairman.
Okay.
What would you do if you were a DPO? Some of you are, but if you were a DPO who observes a seriously unlawful data processing operation in its organization, reports it to the boss, and the boss does nothing, would you notify the DPA? And the sub-question, would you regard it as a kind of normal communication or a whistleblowing act? So what would you do? Seriously unlawful operation, you notify the boss, nothing happens. Would you notify the DPA or find another way to deal with this problem? Who would?
If it's very serious, I would notify the DPA. If the DPA didn't want to do anything, I would blow the whistle publicly.
Anyone of you?
Well, it depends on your image. It depends on your image of the function of a DPO. As in my perception, in the private sector, the public sector is something different. In the private sector, I would think he should be in the same position as another employee who becomes aware of serious illegal activities in the company. What do? There you are, a human being, you have to make a decision. Either you stay an employee with the company, or if it's so serious that you think you can't survive with this, with the knowledge of such an act, you have to whistleblow, which is a big decision.
Yes,
And
that's what I'm asking. Stephen?
I have to say there is a third way that I have utilized, that I've advised friends who are DPOs to utilize in the past. And that is, you send the email that you would send highlighting this unlawful practice, and you forget to privilege it. And that often means that that communication will not be protected. If, strangely, the Data Protection Authority finds out and wants to ask about it, normally I find a non-privileged communication or two. My friends have found that starts to get things moving quite quickly.
Okay, thank you.
May I step in? Only one quick additional answer. I would say the best way is to address this issue very, very clear to the boss. Very clear. He cannot say, I don't know. And then he has to decide. I think in the most cases, the companies have to comply. But if you don't inform him or her, you have the problem. The problem remains to you. And this would be not the best solution.
I can see a nice BBC docudrama on this. But maybe we should go now to the question of the what effect the proposed regulation will have on this relationship. And just to remind you that, of course, that regulation now requires companies of a certain kind to have DPOs and specifies the tasks of the DPO and so on. So very briefly, maybe 2 minutes each.
Yes, maximum 2 minutes, because then I would like to open the floor for questions and comments. So, who would like to begin? Maybe Waltraut?
It seems to be my role to start the discussion. Well, actually, it is difficult to say on what stage of the discussion do we refer now, because at the moment, in my perception in the Council, the situation is so different from the beginning. At the moment, there seems to be a mandatory DPO. At the moment, it seems to be delegated to further legislation of the member states and of the EU. So at the moment, we have no knowledge what would be mandatory to have a DPO. What is, in my perception, perhaps not so ideal, but that is my personal opinion, is that the description of the tasks and the position of the DPO is a little bit, as we say in German, not fish and not meat. That means the formulation suggests that there is an element of a duty to act also not only in the interest of the company where you are the DPO, but also a bit in the interest of the public. And I think this is a bit dangerous. I'm not happy about it. I think one should, especially for the DPOs in the private sector, have one clear concept, what is really expected of this person. Is he a half DPA, so one and a half, a whole DPO and a half DPA, or should he really be a DPO as the employee with the special knowledge acting in the interest of his controller?
Thank you. What's your opinion from the private sector?
Thank you. I think based on what, as Waltraut said, we don't really know what the end result is going to be, but based on what we see at the moment, there is a risk that if you straitjacket a data protection officer into a role that's all about paperwork, and that's all this idea of, you know, running to the Data Protection Authority and reporting, then you really risk that role becoming less effective. Reference the points I made before about my view on the best way to be an effective DPO. That is at risk. I think the regulator burdens in the regulation that we see now also risk the regulator not having the time or resource to do that educative role to develop that role with DPOs. They won't have the time or resource for it even if they wanted to. And I also think the other risk of the regulation is focusing enforcement penalties far too much on fines than on mechanisms to change behaviour. It's far more effective if you get a company to change its practices than just hitting it, you know, with a monetary fine.
Stephen?
I couldn't agree more with the last comment that Emma made, particularly whenever I have been in the role where it's been adversarial. Fines make headlines. Audits and enforcement changes behaviour. And I know that the Information Commissioner's Office, for example, has been criticised for its previous activity on Google, but having them worked within Google, I saw that the fines, they'll get out the checkbook. The audit, year on year, that scared the bejesus out of them. So I would say with great power comes great responsibility for the data protection authorities in the audience. Use the powers that they're going to give you. And if not one line on the new regulation changes, the powers and the scope of the law should be enough to have a fundamental shift in behaviour in companies. So I really, really welcome those aspects of the new regulation.
Well, nevertheless, I agree on strict enforcement policy by the DPAs. I would say DPOs should be mandatory, at least for bigger companies, and they need a specific legal status. We can discuss about on the specific tasks. They should not be paper tigers doing paperwork. They have to play their role in their companies. But this legislation might help them to have an important role. Because without such an obligation, in many companies there will not be data protection officers, and those, and the biggest there are, this is clear. But the kind of definition of independency in their function helps them to convince their organization and to be effective inside this organization.
Thank you. And now questions and comments from the audience. First questions, and please identify yourself and try to draft your questions in a very concise way. Who has the mic? Oh, you need the mic. Yes, the gentleman sitting over there. Whom else? And two others in the left sector.
Hello, everyone. Thank you to the panel for the interesting comments. My name is Elias Okwara, and I'm a data privacy officer of industry in the United States. And I wanted to go back to a point that has been talked about at length, and that has to do with the loyalty that a DPO has. You know, you've signed a contract and you have an obligation to your employer, but you also have an obligation to ensure data privacy, protecting the rights of individuals. And it struck me as that talking about any particular conflict between those two obligations assumes that, you know, my role as a data privacy officer in protecting individual rights runs counter to the business objectives. My thinking is that in many cases, in fact in most cases, those two things are aligned. So by example, you know, when you look at a business, obviously you're looking to make a profit. When you talk about enforcement of privacy, that also falls into that story, because as a business, you don't want to appear in the headlines and suffer a brand damage because of some sort of data privacy breach that becomes reported. And I think a key part of ensuring that business management is fully aware and engaged and supportive of your actions as DPO is really walking with them and communicating. So that means that you explain to them very clearly that if we don't do this, we are going to suffer a fine at some point. If we don't do this, this is going to come out at some point. Now the question is, do you want to take the action now to make sure that we're addressing it, or do you want to suffer future consequences? And as a result, you do see the possibility of individuals within the organization coming to you before things get out of hand and giving you an opportunity to address them. So maybe that's something.
Thank you for this very optimistic approach. We like it very much. The next questions, please. We collect two more. Yes, the gentleman over there.
Yeah, thank you. My name is Michael Hermann. I'm a doctoral student at KU Leuven here in Belgium, and I have a really strong technical background. And while I appreciate the conversation here between the role of DPA and DPO, I'd like to ask the following question. I spent all my working life researching privacy-enhancing technologies or mathematical models to quantify privacy loss when engaging into some sort of services. So my question for the DPA, I guess, is when was the last time that you actually said, okay, here's a result from research, and this is shocking about the quantification, when I see how the privacy of an individual erodes, I must do something about this. And for the DPO, my question is, when was the last time that you saw, okay, here is a privacy-enhancing technology, I can use that, we should use that in the company?
Thank you. And the last one?
Let's start in 5 minutes.
Thank you. My name is Claudia Quelle. I'm a research master student at Zurich University, and I'm looking into the privacy impact assessment. So I'm very interested in kind of the carrots and sticks debate, and I'm wondering, besides fines and reputational damage, what other mechanisms can be used to stimulate compliance and to change behavioral patterns within the organization? And are you optimistic about the role of the privacy impact assessment here? Thank you.
Thank you. Who would like to start responding?
Okay.
Yes, Peter.
These are very serious and important questions, and we have only a few minutes. Well, at first, yes, we, as data protection authorities, had cases where we learned from academia or from researchers that there are risks, and we went into the companies and asked them how they dealt with these risks and how to avoid them. So this was our more or less routine. On the other hand, the problem for the privacy officers to implement privacy-enhancing technologies is that they are completely engaged in compliance work and in identifying risks and so on, that I think they are not the persons who are setting up strategies in the most cases for technology. Okay, perhaps there are differences. There are some bigger organizations where also technical expertise is with these privacy officers. And to the last question, I would say privacy impact assessment, internal data protection organizations, and prior checking and so on. All these are means of data protection management. That means to integrate data protection in the regular procedures in the organizations, and I think this is more successful than only to stick to the compliance with a specific legal requirement.
Thank you. Short response.
Okay. Two things. First of all, on the technology thing, look at the ICO's pages. We have Simon Rice here today. He's doing incredible things about trying to convert academic findings into real-life things that you can do about technology. So I would commend that bit of work to the audience today. The second thing I would say that kind of cuts across both the other questions, I think you're right that that's how it should be, that privacy and business are aligned. But if you're dealing with a very doctrinaire DPA that has a very narrow interpretation of the law, then it's very, very difficult. And actually, I would love to see, I saw in the session before that we're having more technologists come to these type of conferences. We need more pure business people coming to these type of conferences, because I don't think privacy gets business. Never mind business getting privacy. I don't think privacy gets business. And that, I think, would actually help answer the questions that were being asked today.
Thank you. Yes?
I just want to say very briefly, as DPO, you work with all parts of your organisation quite closely to improve practices, and that includes the technology and the IT guys and trying to make systems and processes better. And on things like privacy impact assessments, you have a role as a DPO, that you have an opportunity to lead that kind of work in the organisation and try and get that embedded. And by trying to embed it within the different parts of the organisation, that's sort of your carrot approach rather than your stick. You're basically there to say, I'm here to help you avoid a compliance headache further down the line.
Thank you very much. We started this session a bit late, so please allow us to conduct the last Blitz survey before lunch. Who thinks that the new European Union General Data Protection Regulation will clarify the roles, the relationship between DPOs and DPAs? Please raise your hands. Yes? Who thinks that the new regulation will blur the relationship even more than before? Yes? And who thinks that everything will remain as it is because the general differences between the interests of the DPO and DPA remains like this forever? Maybe. Yes, that's the most popular option. So I thank you for your active participation, and with this moderately optimistic mood, I would like to give back the floor to the chairman for his concluding remarks.
I will only take 1 minute because lunch awaits and it's getting noisier out there. What we've seen, I think, is not only some consensus, but also some differences, and some of the differences can be explained by differences in national law and national assumptions. We've heard that privacy doesn't get business, and maybe business doesn't get privacy. Nobody gets academia. But it seems to me that come back in 5 years and all the guesses about what the effect of the regulation will be might provoke some people to do research projects in the next few years to find out what the answers are and how those answers vary, and to explain those variations. So I think that, you know, many things are possible under the new regulation. I think that possibly Emma's pessimism about paper shuffling and narrow prescription may be one of the hypotheses to be tested. Well, there are alternative ones as well. I just want to say thank you all for coming and for contributing and listening. And also, I mentioned that there were other sessions today on DPAs, DPOs, and whatnot. So those might be of interest as well. I want also to thank the panelists for their contributions. I know we've had rigid time and yellow and red cards being waved about, and I want to thank Yvonne as the moderator again. So thank you all for coming, and enjoy your lunch.